Good evening, this is John Milburn for Laws 11057, Introduction to Law. This is week 9 of term 3, 2017. Tonight we have a two-camera session, and it's to supplement your reading for the week, which is to do with chapter 12, Access to Justice. So what I want to do is challenge you to consider a number of different aspects of access to justice and think about how you might deal with these issues, particularly if called upon to do so in an examination context. So when we talk about being committed to justice, are we talking purely aspirationally? Should we indeed be concerned about access to justice? What is justice, and in what areas of law are we likely to see these issues manifest? Let's firstly deal with the issues of law, the areas or practices of law. When we talk about having access to justice, I guess for each of us we have a different area of law that might come to mind as being relevant. Some people would say that it's to do with family law or employment law. These are the areas where it's clear that people must have access to justice. One of the common areas of law that people think about is criminal law. And having access to justice in criminal law means a number of different things depending on the circumstances that you're discussing. But it might be, for example, that having access to justice in criminal law context means having access to a lawyer. Or it might mean having the ability to refuse to make a statement that would otherwise incriminate you. Or it might be having a fair trial and having procedural fairness within that context. So in criminal law, there are a number of different sub-areas that relate to the general topic of access to justice. But we can go much beyond criminal law. I've mentioned family law and employment law, but what about immigration law? Should indeed people go back to where they came from? And if people are to be given a fair hearing in immigration law, what are the basic rules that should apply in those circumstances? What about human rights law generally? Let's say, for example, to do with the rights of women. That would tie in with issues perhaps to do with family law and perhaps issues to do with domestic violence. There have been many changes of law lately in relation to domestic violence and the different emphasis. Have a look at the Domestic Violence Handbook, which is prescribed and considered by magistrates primarily when dealing with issues to do with domestic violence. What about the rights of people who are subject to mental health issues? Where are mental health issues determined? When we talk about having access to law, justice in law, in the context of mental health, I guess we need to consider where mental health issues are determined or are relevant. Many of you would say, well, when it comes to mental health, it's the mental health court where we need to focus our attention. And while I accept that the mental health court is clearly critical in the context of making decisions about mental health issues, they are issues that relate primarily to matters such as fitness for trial and issues to do with mental health defences generally. I mean, it's possible for the mental health court to find that a person does have a mental health defence of insanity, yet place them on a forensic order, which will have restrictions on that person's freedom into the future. Should we have lawyers represent people in the mental health court? Typically we do. And that's very often legal aid funding for that lawyer. But where else will issues to do with mental health manifest themselves in courts and tribunals? Well, perhaps the second one is the Mental Health Review Tribunal. And that tribunal deals with issues to do with review of decisions made by the mental health court, say in forensic orders, or it might deal with issues to do with ECT, or it might deal very often with issues to do with treatment authorities, which is the old involuntary treatment order. And treatment authorities are authorities which are effectively orders which restrain people from having their freedom, if you like, to deal with their mental health issues the way that they might choose to do so. In other words, the tribunal, by making a treatment authority, gives power to medical authorities to treat people and medicate people on an involuntary basis. So are there issues to do with access to justice that should be of concern there? Often lawyers do appear in the Mental Health Review Tribunal, but not always. It's rare, in fact, in my experience, for lawyers to appear in the Mental Health Review Tribunal to deal with applications about that person involving treatment authorities. The same can't be said on review of forensic orders or ECT applications. But is it truly fair for people to be subject to an involuntary treatment order, treatment authority, without legal representation? Maybe that's an issue for consideration. Where else do issues to do with access to justice occur? Well, if we're talking about people that are disadvantaged, then somewhat aside from, but related to, issues of mental health are issues to do with applications for the appointment of a guardian or an administrator or both for a person who lacks capacity to make decisions for themselves. In other words, we're talking now about the whole issue of the appointment of substitute decision makers for people with impaired decision-making capacity. Now, where are those cases dealt with? And what are the general rules? And do people have representation, etc.? Well, generally speaking, in Queensland, those matters involving applications for guardianship and administration are dealt with in the Queensland Civil and Administrative Tribunal. And that tribunal has the power to make an order appointing someone to become the decision maker for a person with impaired capacity. In my experience, very often people who are the subject of that proceedings do not have lawyers representing them. And in fact, it's very common for people to be made the subject of an order even though they don't appear. Is that fair? Is that access to justice? I'll leave that for you to consider. I should disclose that I am a tribunal member in both the Mental Health Review Tribunal and the Queensland Civil and Administrative Tribunal. So in that sense, I am a decision maker for both those areas. Well, not that sense, but I am a decision maker for those areas. All right, so we're talking now about areas of practice, legal issues that might bring to your attention questions about access to justice generally. What are some others? What about child protection? And in the context of child protection, where are these cases heard? Are people typically represented? And who should be represented in these cases? What's the emphasis? Well, generally when it comes to child protection matters in Queensland, there is, of course, the Federal Circuit Court and Family Court, which deal with issues to do with children and perhaps where they might reside and the extent to which they are entitled to have contact with and communicate with their parents or perhaps grandparents. But what about the protection of the child generally? Where are those child protection matters dealt with? Well, typically in two jurisdictions. The first is in the Magistrates Court and the second is in the Queensland Civil and Administrative Tribunal. In the Magistrates Court, magistrates have the power to make child protection orders, which is essentially an order to protect the child and has the effect of removing them in practical terms and in legal terms from their parents. That's not to say that the order is made to stop the parents from having contact with the children and, more importantly, more relevantly, making an order stopping the child from having contact with the parent. But it's it's putting an order in place which puts the decision-making for the child into the care of the department. So that threshold question of whether a child protection order should be made or not is typically made in a magistrates court in Queensland. But I mentioned the Queensland Civil and Administrative Tribunal. The role that that tribunal plays in relation to child protection is to consider, by way of merits appeal, decisions that are made by the department in relation to exercising or its power as the appointed protection agency for a child. So in relation to particular decisions that are made by the department, they are reviewable by the tribunal. I guess what we've seen so far is this, that when it comes to thinking about the areas of law that have an element of access to justice about them, we need to consider a few things. One is, are we considering access to justice from the perspective of one party or another, or society generally? And how do we go about considering where these matters are heard? What court, what tribunal, and in what circumstances? So we need to understand the procedural sides of things as well. So speaking about the procedural sides of things, as a general rule, there are some fundamental practices that are put in place in Queensland and elsewhere, which can be said to cater for that general access to justice paradigm. So the first is, for example, obtaining a fair hearing. And what does that mean, obtaining a fair hearing? And in what circumstances should that be relevant to consideration? Well, generally, people have a right to be heard in relation to something that affects them. Now, I'll go back to an earlier point. Is it fair, is it right, the tribunal, such as Mental Health Review Tribunal, and the Queensland Civil and Administrative Tribunal, are able to make orders about individuals even though they may not be there? I know that I do make those sorts of orders, but I may be subject to criticism. And if so, what is the criticism and is it well founded? One thing you might consider is actually trying to attend some court and tribunal hearings in relation to some issues. Now, bear in mind that many of these courts and tribunals about these issues to do with access to justice are closed court or closed tribunal, but where they're open, it's always a good idea to attend and get a better feel for it. Okay, let's come back to the general issue of having a fair hearing. One of the basic requirements is that if you are involved in a fair hearing, you have a proper chance to test the evidence of the opponents. We do that by cross-examination. But it's not open slather. There are strict rules of evidence that apply to the way in which cross-examination is done or is required to be done. So let's give an example. In evidence law, there is a thing called the rule in Brown and Dunn. It's based on a case, Brown and Dunn were the participants in that case. It was from the late 19th century. So the court established in that case, a pretty basic rule. It still applies in both civil and criminal cases. Essentially, it amounts to this. Before party B can ask the court to reject the evidence of a witness called by party A and then lead their own evidence to contradict what the witness said, party A's witness must be given a fair opportunity to comment upon and perhaps reject the evidence that party B is going to allege or going to give down the track. That means that the witness called by the first party actually has a proper opportunity to think about the evidence that will be brought by the opponent and then make comment about it. They may say something like, I totally accept that evidence, you're right. Or they may say, look, that's one school of thought, I disagree, most of the people in my profession disagree, etc. So it's all about fairness, obtaining a fair hearing and having an opportunity to properly respond to the opponent's evidence. Now, You'll read about cases that deal with the issue of Brown and Dunn. Let's give one example. It's a case of Smith against Advanced Electrics Proprietary Limited. It's 2005, 1 QDR 65 is where it's reported. In that case, the Queensland Court of Appeal found that the rule had been breached by the failure to properly cross-examine a psychiatrist. And the court held that if the psychiatrist's evidence was to be rejected based on other material that was brought to the attention of the court later, the first psychiatrist should have been given a chance to comment upon the later evidence. That's procedural fairness. That's the rule in Brown and Dunn. So when we're talking about access to justice, what we've discussed so far are really three different things. The first is, what is the area of law that we're discussing? The second is, where are these matters determined? And the third is, what are the rules that generally apply irrespective of where the matter is heard and irrespective of the type of law that we're discussing? Now, as lawyers often do, we say these general rules are subject to different rules that apply in certain circumstances. For example, let's take what you might think is a basic human right or rule of procedural fairness, and that is an entitlement for a person who is accused or suspected of having committed a criminal offence, of an ability to refuse to answer questions on the basis that to do so would incriminate that person. In other words, if a police officer comes to you and says, I want to ask you questions about the break and enter that occurred down the road an hour ago, generally speaking, as a suspect, you have the right to say, I don't wish to make any comment about that. I don't wish to respond to your questions or participate in a recorded interview. That's a pretty basic right. So the rule here is that if you're advising a client who phones you at 10 o'clock on a Friday night to say, I'm here at the police station, what do I do because the police want to ask me some questions? The general rule, almost always, is you should not make any statement or answer any questions. As the lawyer, I would always get on the phone to the police and say, I've given my client advice and he or she has instructed me he or she does not wish to give a statement, or something to that effect. Okay, so that's a general rule. You would think that's a procedural rule that should apply always, but not always. There are exceptions, there are statutory exceptions, where essentially people are compelled to incriminate themselves. In Queensland, have a look at legislation that creates the Crime and Corruption Commission. And in its investigative hearing role, the CCC has the power to compel people to answer questions, even though to do so might incriminate that person. Now, if you find yourself as the lawyer representing a client who has been summoned to give evidence in relation to such a compulsive investigative hearing, then you might consider how you go about discussing the extent to which that evidence, which is given in circumstances where the person is compelled to give it, may be used against the person in relation to prosecutorial hearings at some future time. Anyway, that's for another day. But the point that I'm making here is this, that even though there are some fundamental rights for individuals, there are always the exceptions, and you need to consider that. Okay, access to justice is our general topic. What's another specific area that we can consider? How about this? The issue of burden of proof and the issue of a party bringing an action and the extent to which that party must prove the case against the other side. there are different rules that apply to civil and criminal. So, generally speaking, a party that brings an action in a court is responsible for proving that case. It's up to them to prove their case. That's the general rule. So, if it's a criminal proceedings, the Crown, the police, in bringing an action against a defendant, have to prove their case. And in criminal proceedings, the rule is that in order to secure a conviction, not only must the prosecution prove their case, but they must do so beyond reasonable doubt. I think we all pretty much know that general principle. Now, what's the contrast to beyond reasonable doubt as a standard of proof? Well, we find that in civil proceedings. So in civil proceedings, the party bringing the action has the onus of proof, just the same way that the Crown or police have the onus of proof when prosecuting a defendant. But in civil proceedings, there is a very important difference, and that is the standard of proof. The standard of proof in criminal proceedings is beyond reasonable doubt. The standard of proof in civil proceedings is on the balance of probabilities. What's more likely? If the party bringing the case is able to say, more likely than not, this is the outcome, and the court accepts that, then they would have made out their case on the civil standard, even though the court may not have been satisfied beyond reasonable doubt as to the quality of their case. You should know that and be aware, particularly in answering questions in an examination context, in relation to those issues. But for some bonus points, you might want to consider an important, if you like, modification or extension on the basic principle that a party in civil proceedings has the obligation to prove their case on the balance of probabilities. Now, what I'm talking about here is what's called the Briginshaw test. So essentially it comes down to this. Briginshaw says that even though the standard of proof in civil proceedings remains on the balance of probabilities, the court is entitled to consider the quality of the evidence presented to it in coming to its conclusion. And that will really depend on the consequences of the decision made by the court. Let's say this. Someone wants to bring an action in the small claims or the minor civil disputes jurisdiction of the Queensland Civil and Administrative Tribunal, formerly Small Claims Tribunal. They're claiming $100. They have some proof. The case proceeds pretty quickly. The plaintiff, who has to prove the case, presents the proofs that they have. The tribunal member or magistrate hearing the matter looks at that evidence and says, well, that's good enough for me. I'm satisfied based on that evidence, which isn't much, but based on that evidence, I'm satisfied on the balance of probabilities that you've made out your case. I'll make an award ordering the defendant pay you $100. Now, what if we're dealing with a civil case in the Supreme Court or the Federal Court where the amount of money involved is, say, $100 million? In those circumstances, the standard of proof is the same. It's still the balance of probabilities. But the court is entitled, the court will expect the parties to provide very good quality evidence. In other words, you wouldn't expect in such a case for the plaintiff's lawyers to present a little bit of evidence and say that's good enough. That's enough to show the balance of probabilities. The court is entitled to see the quality of the evidence increase, and this is the Briginshaw test, so to ensure that it can truly be satisfied on the balance of probabilities as to the case that is being brought by the party. So when we talk about access to justice and having a fair hearing, what we're really saying is that everyone has an opportunity to be heard, generally speaking, but there are some exceptions. I've mentioned QCAT and the Mental Health Review Tribunal. Everyone has an opportunity to refuse to answer questions that maybe incriminate themselves, but there are exceptions, the Crime and Corruption Commission. And everyone is aware that the party bringing the case must prove the case, but there are different tests that apply. Let's move on to a different way of looking at the issue of access to justice, and that is the issue of retributive justice, and contrast that with restorative justice. So what do these terms mean? So when we're talking about retributive justice, retribution, I guess we're really concerned about how to best punish a person for something that they've done. Now, restorative justice is concerned with restoring, and it's restoring the healing of the victim, and it's concerned with reintegration of the offender into the community. So restorative justice is looking at the access to justice issue from a completely different perspective to pure punishment, which is retribution or retributive justice. So restorative justice aims to improve the outcome for the victims and the offenders, and arguably society as well, by healing the effects of the crime and not just punishing the offender. So what's the rationale? The rationale is that people are more likely to seriously change if they're working through a system rather than against the system. So the basic philosophy is that the crime is against an individual victim, not the state, and the offender needs to be held accountable and reprimanded by those people that are directly affected. So when you're talking about access to justice and principles of what is fair and what is just, in the context of criminal proceedings, you might want to consider that dichotomy between that which is based on retribution and that is based on restoration. We deal with that quite a lot in a unit that I take, which is Laws 12062, Alternative Dispute Resolution. So tonight we're dealing with access to justice. We've raised a few issues for your consideration. Another one is to do with funding. When it comes to court proceedings, we really can't ignore the issue of funding. Someone has to pay for the proceedings, and that can be the Crown, it can be the society, it can be the individual participants, but somebody's got to pay. So let's look at legal aid funding. Firstly, we do so in the context of criminal proceedings, family proceedings, and civil proceedings. Generally speaking, across the board, legal aid has two tests. The first test relates to the merits of the action. Is this a case worth funding? Is there merit in providing funding? And the second relates to the assets test. Does this person have sufficient assets to fund their own litigation, or at least not rely on state-funded money in order to run their case? So that's the assets test. The assets test is pretty straightforward, although arguably at times unfair. I mean, for example, people who happen to own a home and have some assets may still be able to access legal aid funding, even though another person with exactly the same asset base but in a different type of funding will not be eligible for legal aid funding because they'll breach the assets test. Anyway, the assets test is one thing, merits test is another, and merits test funding in legal aid is interesting in that we need to consider the area of law, we need to consider the court or the tribunal where the matter is being heard, and we need to consider the nature of the hearing within that court or tribunal. And the Legal Aid Office have policy guidelines to generally provide funding as meritorious in certain areas for certain circumstances, but not others. And then there's a whole grey area where you can apply and they're subject to various to some degree, subjective merits tests that might apply. So my advice is have a look at the Legal Aid Queensland website and get a feel for where you could obtain funding and where you won't obtain funding. To counter the issue of costs and the cost of litigation, you would have read about the emphasis placed on creating, to some degree, courts, but primarily tribunals, which are lawyer-free jurisdictions. Now, the rationale is if we keep the lawyers out, that will make this tribunal, for example, cheaper for the parties to participate within, and therefore there will be greater access to justice. But I guess the question that I'd pose is this: if we have a lawyer-free jurisdiction, who actually are we helping and who are we punishing? I guess it's fair to say that there are substantial issues associated with self-representation generally. I mean, many people don't have high levels of literacy. There are issues to do with language difficulties. There are difficulties where people don't have access to or understand the law. There might be mental health or intellectual impairment issues. And of course, there's the whole issue of lack of familiarity with process, where people that are not confident generally may shy away from a court or tribunal, even though it's lawyer-free. So, if we have a lawyer-free jurisdiction, are we in fact creating a regime which has the ultimate effect of penalising those who have low literacy, low intellectual abilities, who are generally reasonably timid and not likely to proceed if they're not familiar with the process? Are we penalising those who are most vulnerable by having lawyer-free jurisdictions? It's something for you to consider within the context of access to justice. Now, you may argue that having lawyer-free jurisdictions is a great advantage to the community generally for a number of reasons. So I'm not suggesting there's a right or wrong answer, but what I do want you to do is think about these issues in the context of the overall discussion tonight of access to justice. Costs remain an important factor when it comes to access to justice. The cost of legal proceedings is high, and if you lose in legal proceedings, there is always the risk, the deterrence, if you like, of costs being awarded against you. And the general rule is that if you bring an action and you're unsuccessful, then not only do you suffer your own legal costs and the costs of the court, but you will pay at least a proportion of the costs incurred by your opponent. So legal costs can be a real issue when it comes to dealing with access to justice matters. So when we talk about discrimination or disadvantage or injustice, in the context of criminal proceedings, I'll just pose this proposition to you. And that is that the prosecution of low-end offences is easier to bring to a court and therefore more likely to be brought to a court than the prosecution of high-end offences. Let me explain that. Obviously, if someone's charged with murder, rape, arson, burglary or robbery, things of that nature, then prosecution will always try to bring proceedings. But if it's a matter of fraud and there's some degree of complexity, it's going to be much more difficult to have the resources available to necessarily follow through with some of those things. Now, I know I'm getting into a political type area, but when I say that prosecution of low-end offences is easier, what I really mean is it's pretty simple to pick somebody up for being drunk and disorderly and put them through the court system. I'm not saying there's anything wrong with that, but I'm just identifying that to some degree, when you're thinking about issues to do with access to justice, is there a situation where those people who are most vulnerable and disadvantaged are the ones that are most likely to be the subject of prosecution because, amongst other things, low-end street offences are easier to detect and prosecute than some of the others. Now, if you've got money and you're charged with an issue to do with, say, fraud, then you may be able to work with your lawyer to argue with prosecution, with the concurrence of the court, that alternate methods of resolving the issue other than prosecution would be appropriate, and really justice mediation is an important aspect of that regard. We talk about justice mediation in laws 12062, alternative dispute resolution. So, again, dealing with the issue of access to justice, I'll just pose another question for you, and that is mandatory sentencing something that affects the poor to a greater degree than it does those that are wealthy? Perhaps it does. All right, so thank you for your patience in listening to me present my material tonight. What I will do is just indicate that next week we'll be talking about issues to do with legal ethics. But as an introduction to legal ethics, I want to pose this question to you. And the question is, as lawyers, is it appropriate, is it necessary for us to give holistic advice? So tonight we've been talking about access to justice. We've talked about some of the special issues that apply to those people that are disadvantaged in some way. When I talk about holistic advice, I guess I could contrast that to medical triage. So medical triage is essentially dealing with someone who is presented, say at the ER, and surgery might be one genuine alternative, but not necessarily the only alternative. There might be other more appropriate ways to deal with that patient. So likewise with legal triage, if I can use that term, you're presented as a first-year lawyer with someone who has a legal issue. You want to provide them with appropriate advice that will advantage them in the long run to the best way. In other words, I think you need to tailor your advice to the needs of the client. So does the law provide justice for all who comes before it? Maybe it depends. And it may depend on the personal circumstances of your client. Is your client genuinely acting on logic, or is your client really motivated by emotion? So I think it's appropriate for you in giving advice to cater for the circumstances of the client. And in doing so, consider issues to do with the intellectual capacity of the client, socioeconomic circumstances of the client, their age, cultural factors, risk perspective, and issues to do with employment, unemployment, income, assets, etc. So generally speaking, if you are engaged in legal triage, I would suggest that you should consider giving, for want of a better term, holistic advice. What that means is don't necessarily look at each problem that's presented to you by a client purely in legal terms. If it's a contract dispute, you might immediately, through your training, start thinking about offer acceptance, whether there is a contract, and if so, what are the remedies available to you. But before you do that, maybe you need to think about other options to litigation. So alternative dispute resolution issues. You might think about ADR in a very wide context and think in terms of a range of different things that could assist your client given their particular circumstances. So we'll talk more about that next week. So next week we'll talk about this issue of holistic advice, and we'll also talk about the issue of legal ethics. If there are any questions, please ask through UCrew. Thank you for your patience tonight in listening through this session. I did have a live session. I had some technical issues, so this is essentially a re-recording of the live session. We'll see you next week. All the best.